From the very first sentence, this defendant walks into court believing language itself is a shield. He isn't answering the judge's question. He's performing an identity ritual pulled straight from internet forums. But courts don't recognize incantations. They recognize jurisdiction, presence, and conduct. The moment he appeared on Zoom, spoke on the record, and addressed the judge, the legal reality he was trying to deny locked into place.
The court will call the case of the State of Michigan versus Eric Martin, case number 23-00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not the legal fiction corporate entity defendant with a name similar to mine. I'm here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it just standby?
Make a decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's how I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's I was going to make the motion to dismiss him if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, so as I said before. So I'm not going to be accepting it.
This confusion over standby counsel is deliberate, not accidental. Sovereign-style defendants often treat legal safeguards as traps because acknowledging protection means acknowledging authority. But standby counsel isn't representation, it's insurance. The judge isn't undermining his autonomy. She's preserving the record so his rights don't evaporate under his own mistakes. Ironically, the very thing he fears is the thing protecting him.
And which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before.
So you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man, so as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent. And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions, though, for the prosecutor.
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
So I object to that. That violates my right to due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, There's no standing, shouldn't move forward, but... So what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether you had a legit basis to make that ruling.
Your objection is noted.
When the judge limits him to 5 minutes, watch how quickly rights become weapons. Time limits aren't censorship, they're structure. Courtrooms run on order, not open microphones. The First Amendment doesn't override procedure, and due process doesn't mean unlimited airtime. What he calls oppression is actually the system preventing one person from hijacking the entire proceeding.
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I already sent to you already.
So first of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
Okay, I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, That's what the terminology demand is made, and that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable rights, right? Human rights and constitutional rights. I'm supposed to be making demands. That's how I've been, you know, and that's backed up by law. That's how I've been taught. And so that's what, you know, it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm just.
So you're about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to. None circular. I didn't finish the first time. All right. Well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
So I'm trying to make.
Well, the police. I want to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination. Move to dismiss the case based on that, because.
Here's where the argument truly collapses. He insists police have no authority over him, yet admits he complied with their commands out of fear of arrest. You can't deny authority while simultaneously acknowledging its consequences. The law doesn't need philosophy when the facts contradict the theory. His own story destroys his position faster than any prosecutor could.
But my memory was a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, you know, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want to be able to review that. Now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given. Violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I'll get that out.
As to your motion to recuse, that is denied.
The lawsuit threat against the judge is another recycled tactic. Sovereign citizens often believe filing paperwork creates immunity. It doesn't. Judges aren't disqualified by retaliation. Recusal requires legal grounds, not personal offense. Courts don't step aside because a litigant is angry. They step aside when impartiality is legitimately compromised. This wasn't that.
But I thought you might kind of already figure that, but conflict of interest due to the lawsuit being filed. That's the grounds of by demand for dismissal.
Okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have. As long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 U.S.C. section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration.
Now the prosecutor enters, and this is where fantasy meets documentation. One by one, she dismantles the filings not with emotion, but with precision. Wrong procedure, wrong court rules, wrong cases. Even the quotes he relies on don't exist. This isn't a disagreement, it's exposure. When arguments are copied, pasted, and misunderstood, they collapse instantly under scrutiny.
That I cited already in the court that they sent back, but one of the main cases here is Packard versus Bantam, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions it specifically, and I'm gonna mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. As they're saying right there, we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stop and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
Anything else, Mr. Martin?
Well, I'm going to see if you got my, if you're going to, I would like to just reiterate my, the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I want to, I don't agree to no unlawful presumptions that, because I understand the legalese a little bit where you say one word and it means something else and it's presumed, and that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm going to be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record. in any public court. This is all public. U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on the screen.
The most damaging moment comes when he explains his right to travel. In doing so, he admits every element of the offense: operating a vehicle on public roads without insurance. Courts don't argue ideology when defendants confess on the record. Legal theory doesn't erase statutory requirements, and federal law doesn't magically void state authority just because someone says it does.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh yes, Penhallow versus Domes Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever. That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows. That does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washington, so just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also, Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal or even a federal lawsuit does not insulate you from the contempt powers of that very same court should you choose to continue escalating that type of behavior. That's just the more you know for me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and titles something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exists in reality. So nothing more from that. The court's rejection of an improper filing really isn't my business, so no response from opposing counsel would apply to that. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands. One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment. Summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the U.S. Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the U.S. Senate. So this court is not controlled by Article 3 of the U.S. Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law and that all state law and state courts are unconstitutional, the state court system would not exist. And the U.S. Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing. I don't think present companies...
Notice the judge's tone here. She isn't angry. She's firm, controlled, and final. This isn't a debate she's trying to win. It's a process she's completing. When she says, "You're not controlling this courtroom," that's not a warning. It's a boundary. And once that boundary is set, the case moves forward whether the defendant agrees or not.
Mr. Martin, if you want to continue without an attorney, you can, but I wouldn't recommend it. That's all from the people.
It's a surprise you wouldn't recommend. You're a prosecutor. Anyway, well, I think that she said so much. I took some notes, but I couldn't take notes on everything. Hard to follow along with everything else. I think it's best to, same with me too. I say one thing, allow her to respond back. She says one thing, then allow me to respond to one set of, you know what I mean? Like me saying a whole bunch. And then sure saying a whole bunch because it's hard to follow along for both of us, I think, harder. At least me, and for both, I think it's common sense, but all right, well, so I'm gonna respond now to things I could follow along with, and I took some notes. What I could, I'm gonna need her to say again what I missed, and then I can respond one by one. Okay.
That's not how this is gonna work, sir.
That's
I
not
think
how
understand here. You
I have the right to that. What do you
you're not controlling this courtroom, sir. That's not how this works.
As I'm speaking about what I have a right to do, I have a right to respond back. So
You're gonna get 5 minutes, and I'm gonna be done. So that is your opportunity. And after that, I'm gonna make my rulings. You got 5 minutes. I'm actually setting a timer.
All right. Again, I object to that again as being violates my due process right to the First Amendment. It's not supposed to be regulated by a certain time limit. My First Amendment right to say what I got to say, based on an arbitrary, unfair time limit.
Sir, in a minute, you're pushing towards being in contempt of court. You got 5 minutes. You can make your objection, which you've done. You got 5 minutes. Now, please move forward.
Criminal. Yeah, I want to object to that too, about what you said about contempt of court. Exercising the First Amendment is not contempt of court. It's nowhere close to that.
There's no First Amendment right in this courtroom, so you're a defendant. You need to actually do what is requested of you, and I'm giving you an opportunity to make your argument.
As to the criminal complaints, in response to what you said about that MCR, the refusal to act on my criminal complaints that I filed because of MCR 6.101. And now, first of all, it violated my due process right, obviously, because they didn't mention a subsection of that rule. There's many subsections. Okay, so I'm still left in the dark in what specific subsection it is. And all those apply to specific fact situations. So that was the first due process violation right there, just mentioning that too vaguely general. Number two, but assuming it was based on not paying a fee or whatever, I think like she mentioned, or getting a prosecutor's approval. If it is for that reason, those reasons are unconstitutional, and therefore it's invalid. That court rule. That's why I'm going to file a class action actually on the court rule. And I'm going to get that court rule and get up out of there, because it's not legit. Why it's not legit? Because as I cited in there, I'm pretty sure I cited in there. If I didn't, I have to check my paperwork. But I'm pretty sure I cited in there, or I was waiting to respond back if I didn't already. But I'm gonna say right now that it violates the court rule the Michigan Constitution part that says that people have the right to prosecute their own cases. In Article 1, I forget the exact section, but I mentioned in my paper, in some future paperwork anyways, I know that if I didn't do it on this one, in the very first one, because I didn't know, what the hell subsection I was talking about. They didn't mention it, but I know I mentioned in some later ones sent to you guys. But anyway, so yeah. So it violates that right. And also, the U.S. Supreme Court case, Murdoch versus Pennsylvania. And I got the volume number, page, and all that. I think I said to you guys before in the paperwork. It says that you cannot deny someone's constitutional rights by trying to make them pay money.
And that's the real lesson of this hearing. Sovereign citizen arguments don't fail because judges are impatient. They fail because the system keeps working without permission. Rights don't nullify responsibility. Paperwork doesn't erase facts. And confidence, no matter how loud, can't override law. The courtroom didn't shut him down, reality did.